Yes, I see people grabbing a Pepsi or a water from the fridge. Good job. Yes, and there's some chips as well in case you're hungry.
Hello.
Hello. There we go.
All right, everyone, please come back, and we're just about to kick off. And so the topic is, ladies and gentlemen, how to resolve disputes effectively and efficiently. And so before we even begin, actually, I wanted to just say, one of our GCs, his name is Dennis, and he'll be speaking tomorrow on the tech panel. And he's the GC of Quest and Ascot hotels and apartments. So he's kindly provided like a corporate special rate for everybody who's here and everybody who's watching the live stream. The text is a bit small, so I'll send this to you guys after the conference. But essentially, you go to the website, you put in a code, and then you'll get an instant confirmation letter, which will give you a corporate special rate at Quest and Ascot hotels all over Australia, which I think is pretty cool. So yeah, just ask me for that if I forget or if you need it today. All right, how to resolve disputes effectively and efficiently. Our speakers are already up on stage, which is fantastic. Our moderator is Tom Bulmer, who's the director of APAC at TransPerfect Legal. Our panelists are Jacqueline Panos, Senior Manager, Group Legal Investment Management at Stockland, Marissa Moko, Chief Legal Officer and Company Secretary at Metricon, and Simone Vrabak, General Counsel at JobAdder. Please, a big round of applause. So again, just like with all the other panels and sessions, if you have any questions, we will pause at the 20-minute mark and open the floor up. But until then, Tom, over to you.
Thank you very much. And welcome back from your coffee break. I hope you're sustained by what was taken on. And also really enjoy that music in between, by the way. You can all have a little dance, keep us awake. So talking about disputes today and litigation or everything leading up to that as well, and we've got some amazing things to talk through from the calls I've had with our esteemed panelists. To kick us off, I'm Tom Barmer, as he said, work for TransPerfect. We work within disputes for in-house teams, managing the data involved, basically. So helping them collect it, figure out what's relevant, review it, and then submit it to the other side. We help do that really efficiently. So if that's something you're interested in, you can come chat to me afterwards, but that's enough from me. Would you guys like to introduce yourself in under 30 seconds? And the more you're under 30 seconds, the more points you win. How about that? Do you want to kick us off, Jackie?
Sure. I'm Jacqueline Panos. I am at Stockland at the moment as a senior manager in the capital investments team. I've been in government, I've been in private practice. I've seen disputes from the start of my career, and I'm looking forward to sharing my insights here today.
Awesome.
Impressive. I'm Simone. I'm from JobAdder. I'm the General Counsel there. Like Jacqueline, I've been in-house private practice and government at the ACCC early on. So I've been everywhere, man. We do recruitment SaaS for agencies and in-house teams. So everything in the kind of up to a hire for a business, our software managers.
Hard act to follow, of course. Marissa Moko, Metricon Homes. I'm like Jacqueline and Simone. I too have been everywhere. I've started my career in government, been in private practice, and now in-house with Metricon. We build about 6,000 homes a year. And of course, we don't have any disputes. We're all for our customers. We do a great job. But I have been involved in plenty of disputes throughout my career, so happy to share my thoughts and learnings today with you all.
Fantastic, thank you. So to kick us off, I think a lot of people in the room would hope to avoid disputes at all costs. They are expensive and troublesome and annoying. but also fantastic if you're a litigator. But regardless, can you give any advice kind of in that realm around avoidance, mitigation, whether that be at the contract stage or when you're launching a new product, or however you want to address this question? I'll leave it open to the floor, but just risk mitigation and trying to avoid them early on.
I think for me, one thing I always look at is looking at the relationship between the parties before entering into a transaction. It's the honeymoon stage, and if things don't look rosy at the beginning, it's not going to look any better later. So be very mindful of watching your stakeholders negotiate transactions. If you see that things are not as rosy as they should be, you should be maintaining a good document management system, ensuring that they understand what legal professional privilege is, using that as a tool in informing that relationship, because you never know when it will be pear-shaped and when you'll need to rely on those documents again.
My experience is a little bit different. So we've got 5,000 customers on our platform, and it's B2B SaaS, and anybody who has been in a SaaS world understands that every day is precarious, right? Like there's some dev team that actually accidentally switched something off and now there's an outage in AU5. So every day there's kind of this risk of disputes, and early on I identified like this is going to happen frequently, and when disputes come in, they're going to be a lot at once, and it's going to be a lot of like angry customers, not always necessarily with a legal basis, at least to start. So in terms of like mitigating the risk that they become actual legal disputes that need my involvement, we've tried to, and again I preface this with, we have a unicorn customer support team and customer success leaders. We've tried to playbook out kind of the major categories of things that start small but risk becoming big, hairy, scary if we don't deal with them early, and ideally they don't come to me when they're early. So we've actually got a disputes playbook to kind of try to mitigate the risk we end up in a litigation context, and to kind of deal with large scale kind of issues swiftly in a way that they feel in control. And I think that mitigates the risk that things ultimately become litigious or legitimate disputes that I need to be involved in.
Fantastic. I think what I would add to that is just ensuring that you're not just focused on the deal that's in front of you, but looking at everything that may surround that deal. So what may happen in the future? What else do you need to be thinking about when you're looking at drafting those contracts? And sometimes you've got a business area who's very focused on, we just want to get this deal done. We want to either enter into the contract with the developer or the business or the customer, but they're not looking at what could potentially go wrong in the future in terms of, will the supply chain be stable? Will other things impact this particular deal? And when we're doing things at a fixed price, make sure that you've taken into account what that could look like and what that might mean in the future in terms of cost escalation and other things that you might want to build into those contracts so that you don't have to have a dispute. It's already at the forefront of parties' minds when you're entering into those contracts at the start.
That's really interesting, and I will come back to your playbooking out disputes because I love it. When dealing with that at that early stage, is there any advice around dealing with the stakeholders who are really excited about getting the deal done, and like, you know, they want to potentially cut some corners, and you're like, whoa, what's the best way to deal with that? Any advice around that?
I think just always keeping it real.
By the way, I'm that stakeholder typically, so I'm the one that's really excited and going, oh guys, come on. So yeah, dealing with me, how would you do that?
I think it's just a matter of, you know, again, playing out what is that worst case scenario and making sure that everyone is working towards that common objective of, yes, we want to do the deal. Yes, we want to get this done, but what else can we do to make sure that we're safeguarded in the future? And also, how do we feed back in those learnings that we may already know from those projects that perhaps didn't go as well for us? So it's always about making sure that you're bringing back together all of that information that you know, and also just managing that expectation with that stakeholder who may be a bit excited and want to get it done, or who says, hey, we've done this 1,000 times before. That's great, but let's look at it for what it is today in today's environment before we go forward.
Do you want to go next, Jacqueline? Oh, thanks. Okay, so when it comes to the kind of like the real as in like the contract negotiation and the risk of disputes, I kind of like to try to put the consequences in quite tangible terms for the business. So sometimes the idea of a dispute or what could happen is abstract and quite abstract, and all they see is kind of a revenue figure that you're like between them and that revenue or that target or whatever. But kind of playing it out in terms of real dollars or real risks can crystallise in their mind the reason why we need to negotiate something, and kind of opening up avenues that are not just, well, you know, it's kind of the, well, if the party can agree to this, you know, within our risk appetite statement, that mitigates things to a level we can accept. So I think there's kind of a way to still create the perception of like we're moving this thing, but also we're protecting ourselves in the process.
I think it's about being solutions focused with the business. It's really setting up partnerships with the business well before a dispute comes, that they trust you to come to you, to tell you that something's going awry, before it explodes and snowballs into something a lot bigger. And to answer your other question, in terms of mitigating risk to litigation as well, I ghostwrite a lot for my team. So, you know, not in legalese, obviously, but trying to diffuse a dispute early on is always best. But to be a business partner effectively by ghostwriting for them can also diffuse a dispute very quickly.
And so you'll empower them to continue the conversation themselves, but just provide them with...
Yes, it empowers them because they're the ones that set up the commercial relationship. I don't want to be there to be their handbrake to happiness, as most in-house lawyers are called, which is not true. But yeah, it's really a facilitation process for them.
Yeah, that makes a lot of sense. And you mentioned about legal professional privilege, LPP. Been in the news recently with the Medibank Deloitte report and Numi versus ASIC, which is a really interesting one if everyone hasn't seen that. Any advice on handling this internally, reducing the risk around it being misused or misunderstood? Because as soon as people see a lawyer in CC, they're going to think, oh yeah, I'm privileged, I can say whatever I want. Coming from, again, me being the worst example ever. But any advice around that?
I hold workshops a lot. I always have a lessons learnt after a dispute, saying if this came out in the public realm, this would have been disastrous. Or this did come out, let's not have this happen again. Without pointing any fingers, obviously. But it's really about educating the business about what legal professional privilege actually is, that it's actually a very powerful tool, and it's something that they should use, within reason obviously, to protect their business. So it's about understanding something that is complex to most people, I think.
Well, I'm kind of nervous that my own communications may not be protected by privilege because I'm so commercially involved or wear both hats. So this is even for myself a constant challenge to have to navigate. Like, now I'm in my legal hat. I'm not going to kind of be commercial here or, you know, kind of get out. This is predominantly for legal advice. But like in terms of practical steps, one thing I always do when it kind of gets to a point where I can see something is becoming quite hairy is just we are going to now centralise the comms in one of two places from a document management perspective, right? Because the real risk for us as a business is like Slack is everybody's best friend and there's like side chats and, you know, I'm just going to quickly go, you know, forward Simone's thing to so-and-so. So one of the things I do is really like contain a team, like this is our team now on this. This is where everything goes. This is a special area we create for what we think is legal advice or where you are seeking legal advice or where we have something from an outside lawyer. So in practical terms, that is the best I have in terms of protecting privilege. And it's not perfect either. Like the business is still a little bit loose, but at least I have a good handle on where most of the document trail and the skeletons live, which is better than nothing, I guess.
I think that's very important. And I think to add to that, I sometimes have labels. So if there is something that's not meant to go for greater circulation, you put that at the top, you know, not for broad circulation, this group only, and just directing the traffic on those emails and how they're to be used. And then again, bringing in the team who are to work on a dispute and to be in the tent and saying this is the parties who will deal with this and this is how we go about the transaction and what that looks like. I think being very intentional about that is very important from the start and setting it up just so people do know there is a net over this for a reason, and we're working towards this, and we want to make sure that whatever we do, whether like we've seen in some of the court cases that have played out, if we're getting a report, that has to come through legal. How do we brief for that? What's the purposes? What does that look like? We deal with experts quite a lot in our area in terms of if there is a dispute, we get an expert involved, and very rarely will we let the teams, engage that expert themselves, because again, it's about keeping that legally professional privilege over that document if we don't want to be using that report, and what does that look like? So that's, I think, all really great tips.
Yeah, awesome. You both mentioned, Simone and Jackie, about document management. This isn't me doing a plant for what we do, but how important is that when you're thinking about litigation, and is there any advice around kind of handling that internally? And if you want any more advice on this, obviously come to us afterwards. But information governance and kind of getting your ducks in a row and that kind of stuff.
I think it's very hard to do, in all honesty, unless you have a directive from the top organising how documents are meant to be stored, labelled, and so where I can control document management is obviously within the legal team. And that's obviously securely stored, filed away perfectly, subfolders, as many programs as I can use, automation. They're the sorts of things that we need. We're a document repository as well as in-house counsel. People come to us for things all the time. So although when you're looking to commence proceedings, for example, legal will be the depository of all documents. So that's where it's useful to be very organised and have your documents stored securely and in an organised fashion so that you can assist the business in commencing proceedings easily.
So we're not a very litigious business, to be honest, and most of our disputes never really get to that point. But the thing is, actually, I'm kind of lucky. There is a bit of a reverence for legal in the event of a dispute. Like, the whole reason we had to playbook out our disputes area is like, customer support was so gun shy. Literally something mentioned the ACCC, and I hope Day One Recruitment aren't here. You're the exception to the rule because you're one of our customers. You know, recruiters consider themselves a bit bush lawyers, so they'd come with some like clearly AI generated letter of demand or something, and support are just like, oh my God, like they're gonna sue us. So like, when I say to an area, actually, oh, you picked a good one, like this actually could get serious, or like this is from a proper lawyer, guys, well done. They're quite compliant in a way, so I get to dictate, I guess, how and when we're going to store things and how we're going to manage that, and we do try to create sort of a central folder per dispute that gets to that point, and I do find that a lot lives there. But yeah, it's about really, and also we're a pretty lean, mean fighting machine, to be honest, as a business. We're only 250 people, so it's quite easy to dictate how something's going to be done, and we don't have like a crazy number of systems. So, you know, to say, okay, we're going to label this Google Drive area like highly confidential, and you're only going to get access to the folder because you are a person in the tent, it's not been overly complex so far, touch wood, like everybody pray for me. Sorry, that's my answer.
Do you want to, Eva, any thoughts on that?
No, nothing to add.
Okay, cool. So there's been an issue with a project or a client, a dispute is possible or likely. Any strategies before anything becomes too formal? And I would love you to talk a little bit more about the playbooks if you can. But I'll start with you, Marissa. Any like strategies before that kind of more formal letter of we're in a dispute now to kind of avoid it? Tips?
I think in terms of tips, understand who your client is. And unfortunately in today's world, I think if a customer is coming to you, your client isn't just the customer, it is Facebook, it is product review, it is a public forum, and it's also can be played out in the media as well. So my tips would be to ensure that you know who you're dealing with, what the extent of it is, what that person's background is, and really to understand what is their issue, and also what have we as a business done that has contributed to this issue, and what can we do with the teams involved. And also looking at sometimes, I know that from our perspective, our teams are working to different KPIs that aren't necessarily a dispute resolution focus. They're more focused on budget restrictions and restraints. And sometimes it's about getting to the bottom of, okay, who can give me authority to be able to settle this dispute, which might not align with what the manager wants to do, but aligns with the overall ethos of the business, which is customer first. So again, it's just about setting up who is that dispute with, and it's not always with the customer, sometimes it can be with a stakeholder as well, in terms of ICT contracts or developers or those sorts of things. And that's, again, just knowing who that client is and making sure that you understand what the dispute is.
Yeah, I think from our perspective, often before it becomes legal, the customer is just angry, either angry at us or angry at another customer where they try to make us the meat in their sandwich, or, you know, they're just angry. And this is what I've had to educate support on. They may be throwing some legal terms in there. They may have CC'd their aunt who's a lawyer in on that thread to make us think it's legal. But like, first and foremost, they are angry. They want to feel heard and they want to feel like we have done something. So we are in the quagmire of kind of a lot of our businesses we deal with, our customers are SMEs. So consumer guarantees, unfair contract terms, under $100,000 contracts, you know, they actually do have some right of recourse. So, you know, first step, if we really see a rager, is kind of like, let's just have some pre-agreed amounts we can give, right? Threshold amounts that you don't need to come to me. We've just heard you're angry, right? You go, you get a month's credit with Job Adder. We really understand that, put your business out, right? You know, next escalation, final escalation, oh, they've engaged a lawyer, is me. So I think that really helps diffuse a lot of situations where the customer just feels frustrated or angry because their business was put out, and quite frankly, they don't want to engage lawyers or can't engage lawyers or don't want to go down a lengthy path with us either. And it kind of gives us a consistent approach if we did have a regulator come to be like, look, we understand we have obligations under the consumer guarantees or whatever else, and to honour those, we tried these steps. So yeah, I think it's really about understanding that generally in a customer dispute, in our space at least with SMEs, their first issue is they are frustrated and they want to feel heard, and really making sure you kind of empathise with what your action or someone else's action potentially has done to their business.
Thanks, Simone. Sorry, I was just going to press pause. 20-minute mark. Questions about disputes, resolving disputes. I've got one hand from Team Beta in the middle here. Any others? Any others? Team Alpha, just not doing well today. All right, Team Beta, if you could introduce yourself as well.
I'm Tin from Next Payment, fintech company. So when it comes to dispute, the final stages, the compensation amount, you just mentioned that the threshold. Now, how often do you consult with CFO or the executive team? What will be the amount that the company will be happy with? Sometimes I find that even if we agree with this, for example, sales manager, give me the figure, hey, that figure is fine, and the CFO might disagree with it, hey, it's too low or too high. How often do you, as a GC, consult with the executive team, in particular CEO, CFO, or how often do they find that, hey, it is acceptable or unacceptable, or maybe it's too low, too high? How do you manage that figure?
Yeah, it's a good question, and I think our first step when we set up the playbook was to get buy-in from finance and our CEO on the level of risks we were taking there. So the first thing so let me just talk through a little bit of this. If it is our product that has had some sort of situation that's impacted a group of customers, or a fairly substantial number, say, the first thing that support do is prepare an FAQ document on what's happened, and I have to review that. Then they have to identify the number of impacted customers, because we have a pre-approved pot from finance, which assumes the 3 tiers, right? If it goes above that threshold, then we need to go back to finance to have that discussion. But effectively, finance has already pre-approved kind of certain thresholds within that playbook that we just don't need to hear about it, because we have foreseen, or there is budget for that, right, over the course of a year. Obviously, if that pot runs out or something happens around that, we go back to finance. But in the main, it's kind of, there is a known risk here, and to mitigate the time used by me, the time used by finance, the time used by our CEO every time, we've kind of aligned on a certain monetary figure to resolve disputes within that category of dispute type. Does that make sense? Yeah.
Any other questions?
Any other questions? All right, back to you, Tom. We might save some space for one question at the end.
Okay, just one. So make it a good one, Alpha. So we've hit formal dispute resolution. They just won't listen to you, or the different levels of money that you're offering them. We're now in a dispute. Oh no. Let's learn. Let's talk strategy, advice, war stories for the audience to learn from. Marissa, first of all, you asked about I asked you about kind of traps and pitfalls that you can potentially fall into. Do you have any advice around what they are and how to avoid them?
Yeah, absolutely. In terms of traps and pitfalls, I think it's not having the relevant information to be able to resolve the dispute, and as well as knowing what that outcome and how high your board will accept in terms of what that's going to look like. And I think when you're at an impasse with a party, it's about looking at, okay, what's the surrounding facts? And maybe we're all too focused on the big issue, but what are some of the smaller issues that we can tick off and feel like we're getting some progress and traction within that dispute itself? And sometimes that in itself can help, because it feels like the parties are moving forward, even though the big issue perhaps still isn't being addressed and can't be addressed. And unfortunately, sometimes you've got to look to, do we bring in a third party here? Do we look at engaging with a barrister who's going to be almost like a referee in an informal mediation sense, in terms of, we don't want to go off to court, it's going to be expensive to do so. And of course, sometimes we do end up in court, and that's the only place that these disputes will play out at, which is obviously what we all want to avoid at every cost and every turn of the way. But if you've got that sort of customer, or you've got a big dispute, that may be the only place to go, but you can certainly set yourself up for success along the way and do all that you can by bringing in those third parties early to get that advice. And then also, again, I think adopting some of the strategies that Jacqueline was saying about being that ghostwriter. So you don't want to come in too hard and guns blazing. Sometimes you want to leave legal dry for like those really, really big disputes, but at the same time, you're sort of in the background playing that role. So that's how I would, my tips and tricks.
Love that.
I think something I've noticed with our business when something gets hairy is they fall into I would say the panic trap. Like, they've given us a deadline of Friday, or they're going to initiate by whenever. And I'm like, just calm the farm. Like, I'm pretty sure they don't want to litigate as much as we don't want to litigate, right? So I think one of the traps is falling into someone else's time pressure or deadlines without fully considering your position and how far you're willing to go, and have we really exhausted all avenues for resolution here, and has our CEO got on the phone to their CEO? Like, there's a lot of steps that can be taken, which I think particularly, actually even relatively senior business stakeholders will fall into the trap of, big client has a lawyer, told us they're going to initiate by Friday unless we do something. I'm like, kind of, we can take that information and do more with it. So I think my big learning, particularly the more of these I've seen over time, is like, that is a signal at best, right? Like, there's still room for us within that time frame.
So they're the 2 points that Simone is saying. It's really staying calm. There are a number of crises that I've faced with former employers, such as facing ICAC investigations and really, really serious things that are out of our control. But it really is about staying calm and really understanding what the true issues are and seeing how you can resolve them. So it's really also understanding what your client's bottom line actually is, and that bottom line will change when you tell them the cost of litigation as well. So instead of I always tell them, don't pay the external lawyers, pay your counterparties and mitigate that reputational risk as well. So the bottom line does change. And it's very important to nip it in the bud early.
You also mentioned about communicating with the business. Outside of the ghostwriting piece you mentioned was picking up the phone as well.
Yes, pick up the phone. So what freaks me out the most at the moment are WhatsApp messages, Teams messages. And I've had situations where there have been incidents on site where we have workers that are injured and there are 50 WhatsApp groups that are set up all about it, and not a single lawyer is involved and nothing's contained with privilege yet. That's my worst nightmare. And so I really believe in implementing something like an incident protocol in those situations where it's very much call an ambulance, call your lawyer, call your internal lawyer. That's your second person to call. Pick up the phone and reduce communication in writing, because all of that can come out in the wash.
Yeah, we see that a lot. It's really interesting in our industry. Like everything used to be, yep, we're doing emails and there's some stuff on a file share. Now we're talking WhatsApp messages. We're talking WeChat messages a lot with the stuff we're doing in Asia. Talking about like internal communications within bespoke project management platforms that we have to get access to. Like how do you, like, and people become very unguarded in those short messages. They're not sitting down and writing an email, going away, thinking about it, and oh, I might have said that in anger, and maybe take that out. They are sending the message before they've even thought about it, and then they will regret those. And that comes up in those pieces of litigation we're involved in. But, anything you want to add, Marissa, to that around communication?
The only thing I will say is one of the worst things when you're going through documents for a dispute is emojis. It's really embarrassing, guys. Don't use it.
And memes. Stop the memes. Stop the memes.
Lots
please.
of memes. Lots of memes. Unless they're funny ones, we'll keep them in. And so you also mentioned, we were talking about kind of data retention, archiving, and communication, and how important that is when a dispute hits. Just some more stuff to talk on there, Jackie. I know we talked a bit about it.
Sorry, what was that?
The kind of we talked a lot about communication and the data involved and that kind of stuff. You spoke at the start about making sure that none of that's moved around and there's certain folders and things.
Yes.
Any advice in that area for everyone in the room when they have to face a dispute?
Well, once you're facing it, you need to access it quickly. So obviously making sure your backup, making sure your IT is really good, really. I mean, work with your IT department as well. They can be your best friends because they will be able to draw documents that are archived that are no longer in your inbox. So work with IT as well.
Awesome. Did you have something to say?
No, I'm good.
I think the only thing I'd add to that, I know when we get to a dispute, it's usually been touched by about at least 10 people in the company, and sometimes those people are no longer around. So just having an understanding of who's got what in their emails and where they may have stored it. So again, it's about making sure that you've got a process or protocol in place that when people do leave the company, their emails are archived and you can get a hold of them. We call it lit hold internally, but again, it's not perfect, and that's probably where you need someone like Tom to help you.
I honestly didn't ask her to say that, but yes. Correct. Litigation hold, it's the first thing. We get involved at that stage when the company's kind of saying, okay, we need to assess what data we need here, and we have an initial call with IT, the legal team, and the external lawyers they've involved to just talk through data sources. And the amount of times, like I say, it's emails, file shares, and we go, does anyone communicate on their phone? Oh, they shouldn't. And then the custodian's going, yeah, all the time. We have a WhatsApp thread. I message my like main counterpart on the project. We have site diaries on our WhatsApp threads that we've taken, and there's some pictures. Right, okay, so phones, yep. And then, it's a mess. So it's something that you really need to consider and not make any rash decisions until you've got an expert involved.
And what I tell my people is, if you're comfortable having it on the front page of the Telegraph, you can put it in writing. Otherwise, don't. That's pretty much, it's very simple.
Totally. And we talked about third-party support. You mentioned it briefly, when to bring in those kind of third-party experts. Like, when is the best time to engage them, and like, who do you turn to first? You mentioned barristers. Would that be your initial phone call, or?
Sometimes we go to our panel firms and we instruct them in terms of, look, this is the dispute we've got, this is who it's with. Again, it depends on what's involved, but if we're using a barrister, it will usually be something highly technical, and we will direct brief and we'll get their opinion. We find that that's actually been really useful in some of the more nuanced issues that have sort of come up since COVID and those sorts of things. And also sometimes we use barristers as tiebreakers to get the parties in to have that informal mediation, and they can really test the parties on saying, well, look, if this does run to court, my experience is A, B, and C, and you're probably not going to, get up on some of these arguments, or it's going to be very costly. But it really tests the parties, and they're no longer hearing from you as a business, they're now hearing from an external party, and you've both engaged with that person, and so everyone's there to collaborate on what that looks like. I've found that that's been really useful.
I think just like everything at JobAdder, it's tiered, right? So we have external support in our kind of key markets on that kind of all-you-can-eat lawyer basis, like the Legal Visions, the lawyers on demand. And if we just need a kind of lawyer on a letterhead to kind of, we're taking this seriously and we outsourced it. We will, sorry guys, I know one of our providers is here. We will send it to them. If it is like, oh, they've got a grown up, like a barrister or someone, then I go to the business and I'm like, they've got a grown up, we need a grown up. So I think it's like, what are we actually facing in terms of what's come? And so what level of external support do we need to put to the kind of issue?
To add to these excellent points, don't forget your insurer. Let your insurer know and let them know early. Not when a statement of claim comes in, but when a letter of demand comes in. I do it early. Might waste their time, might waste my time, but I find that letting them know early is also helpful.
And also because they would just have a lot of experience in litigation.
True.
And you can draw from that, like the people that we're dealing with as well, there's lots of insurers involved. Not just the legal teams, but the claims managers are all very, very astute with strategy and that kind of stuff. So in terms of the, we've done third-party support. I was going to ask, how do you choose them when you go externally? Is it like, are there any metrics involved? Are we doing it based on reputation or someone you trust?
Again, it's a little bit like Simone's approach. If they're using, if they come to us and they've got a boutique firm, we're not going to go top end of town because that's just going to look like bullying. If it ever does end up in the tribunals or the courts, it doesn't look good. So we tend to match whatever they've got. So if they've come to us with a smaller firm, we'll also engage a smaller firm. If it is a bigger issue that's going to have some real meat behind it, then yeah, we will go top end of town and we'll moderate in terms of what that looks like.
That's super interesting. Matching, love that.
Oh, that's good. I never thought of that. Good one. I just generally use known and trusted litigation teams that I've used before. There's too much at stake to try someone new unless it's a different area of law that I haven't been involved in before. And normally if you use the same few lawyers, they know the company's risk appetite as well. Yeah,
fair. Then we're seeing a lot in the news around kind of litigation trends and like a lot of companies who've never had litigation are now coming to us for advice. And what are the trends, the things you're seeing that you're most worried about in the next 6, 12, 18 months? Want to pick us up?
Yeah, throw that down the end because I haven't really
Sure,
thought about
Jackie.
that. Me?
We're just going to have a think first.
What I said before really, which are limit your communications, WhatsApp and Teams and all those platforms are what keep me up at night.
Trends that keep me up at night. So we are the data source of truth for a lot of recruiters and in-house teams. So think about any time you go for a job, you give your passport over, there's criminal checks. Yep, we store all that. So privacy is our big risk, right? So what keeps me up at night is risk of a security incident, this sort of emergence of class actions in privacy contexts, contractual obligations that we need to agree to get some of the bigger global recruiters like your Hayes and your Adecco. So yeah, it's more, I mean, don't get me wrong, the regulatory threat freaks me out separately, but from a purely disputes perspective, it's that people are sort of banding together smaller customers that historically you'd be like, they're not really going to take an action because they're small. Well, guess what? Now they are. And contractual things we have to do to get certain deals over the line in terms of data commitments.
Yeah, and I would certainly agree with that. I think we've certainly seen an influx of, Facebook pages, as I said before, product review. People do now have a very public forum to air their griefs. and I think that in itself gains momentum, and we've certainly seen that sort of swell as well, and the media too is always looking for someone to go after and to have those conversations about, well, what does this look like and what is this company doing? So I think you always have to go to check what is our response to these threats, and is it moderated, and what does that look like? So absolutely.
Awesome. We have 2 minutes 43 seconds for Alpha to come up with a question.
Alpha. They really want chocolates. All right, I've got 2 hands. I'll come to you, Wendy.
You really weren't wrong about the 24 clock. I feel like Jack Bauer.
Hi, I'm Wendy. I've just got a question in relation to how your front-end contract drafting and negotiation informs the back-end dispute management, and how you intertwine that now with the unfair contract rules.
Well, I'll start because we've got a lot of small business customers, particularly. I think the reality is some of our terms have not been tested, let's say that. We never want them to be tested, really and truly. So this has, again, informed some of the decisions in the playbook. We don't really want to get too heavily into, well, clause so-and-so of our contract says you have a, limitation of liability of this long. Ideally, before we are ever at that stage, we've just solved it by giving them something that falls within their liability cap. So I think we have our ideal position standardised in our terms of use and but do we want to test it at the back end? Not really, which is part of why we implemented the playbook to begin with, because that is a big risk mitigator of us actually getting tested or them getting lawyers and actually combing through our terms, because there is a risk element in them, as I'm sure there are for many on standard form contracts.
Thank you. One more question.
Hi, I'm Tess, GC at CBRE. I'm interested in your point about the insurers, because we've ended up with disputes where their interests in solving a particular dispute for as little as possible really diverge with our interest as a long-term business and having long-term relationships with these big clients, and trying to sort of get them to understand that saving $1 here is going to cost us more in the longer term. It's been difficult.
I can understand that, and it may just be that at times you may have to supplement it. It depends on how important that reputation is and how important that dispute needs to be resolved. It is a tension. Understandably, insurers will find any way not to pay out. But sometimes it's just a matter of really having to top it up, because no policy is going to cover, for example, reputational damage.
Brilliant. We are out of time. Please give our panelists a big round of applause. Tom, Marissa, Simone, Jackie, thank you so much. All right. Quick question. How many of you negotiate contracts as part of your job? Hands, 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 hands. If you are not raising your hand, please have your job. That sounds like an awesome job. The next panel is called The Secret to Negotiating Technology Contracts. And even though there's the word technology in it, I think a lot of the principles that we'll talk about will apply to pretty much any contract. And so please welcome our moderator is Greg Palumbo, partner at Maddox. Our panelists are Asha McDermott, head of legal Australia and New Zealand at Ingram Micro, Ivana Kovacevic, group general counsel at Tabcorp, and Janine Kane, chief counsel Asia and emerging markets at Thomson Reuters. Big round of applause, please. Excellent. So before I hand over to Greg, just a quick note. This is the last panel before lunch, and I've told our team in the lunch room, which is just this room here, that you're not allowed to eat until after this panel. So do not try and grab a cheeky butter chicken slider while we've got this panel going. The food is Indian fusion, so if you were here last year, you might remember that. If you weren't here last year, you missed out, but you can get to experience it today. Tomorrow's food is Mexican, so if you like Indian, today is the day to be here. And Greg, over to you.
All right, is this on? Can everyone hear me all right? Yeah, we'll try to keep it interesting before lunch. I know everyone's quite keen for that. Sounds delicious. So, but before I introduce myself, I might pass over to the panelists to do a quick intro for yourselves. Janine, do you want to start?
Hi, everyone. Is this working? Nice to see you all.
Janine, it's, you just need to press the button up.
Sorry. Rookie error. Can you hear me? Gosh. Okay, now you can definitely hear me. Hi everyone, I'm Janine from Thomson Reuters. I look after a region comprising APAC, Middle East, Africa and Russia. So it's a pretty vast area. I actually just wanted to use this moment to thank you because I have found the WhatsApp group amazing, Rohan. So I really appreciate it. And those of you who've answered my questions in the last few days, I'd love to meet you. So thank you. Nice to be here.
Hi, that's working. Okay, that's too loud. Hi, I'm Ivana Kovacevic. I'm Group General Counsel at Tabcorp, and I also have to just second that. The WhatsApp group is amazing. Well done, Rohan. Thanks.
Hi, I'm Asha McDermott. I'm Head of Legal at Ingram Micro, which is a tech distributor, and I'm working across Australia and New Zealand.
And I'm Greg Palumbo. I'm a partner at Maddox in the technology, media, and telecommunications space. So I negotiate technology and commercial contracts for a living. One thing I also can add here is a little bit of both sides on this. So I represent both customers and suppliers. So sometimes our panelists will have a perspective, but I might try and balance out some of those things, and I can do so without talking about any specific clients, because you don't know which one it is. So it gives me a little bit of ability to talk and provide a bit more of a perspective. Now, just did want to say on that we're obviously here to kind of talk about the positions and the ideas and not necessarily how each one of these people would negotiate a contract. So just putting that out there, because I'm sure there are some customers or suppliers that they all have. So just putting a little disclaimer here as to we're just going to try and talk at a more theoretical level sometimes. But one thing I did want to just get into, and what I thought about when talking about technology contracts, was what was a good example or experience that I had that kind of conveyed what I think is really important about technology contracting in particular. And so before I moved to Australia, I actually was in-house counsel for 4 years at a global hospitality company. And we used to get all sorts of interesting things come across our desks of what we had to do, one of which was the world's first robotic concierge. And so this was a little R2-D2 like contraption that would deliver towels to your door if you had a need. It was a marketing gimmick, let's be honest, around it, but it had some real risk and liability attached to it. So I really needed to understand, what exactly are we doing here? What is it going to do? How is it going to operate? What are the risks? And making sure that people understood what could be happening, so we could start thinking through some of those issues and then dealing with that contractually, both with the vendor but also other vendors. So an example might be the robot had to interact with the elevators, and okay, well, what did that mean? How did that interact with our contract with the elevator maintenance and operators and things like that? So really understanding what those risks were and what the actual product was and how it was going to operate was really key. And so I thought, just to start off, I might pass over to each of you and see if there's one, well, let's say, war story, anecdote, learning, good example from your experience that kind of was a really good learning moment.
So this actually is an anecdote from a colleague of mine who I was speaking to recently. He was telling me that he'd been involved in a negotiation around some very innovative technology with a customer for ages, and they were just batting things back and forth and getting nowhere and getting very frustrated. And then the lawyer on the other side said, I don't really understand what we're talking about here, and I'm a bit nervous about it. And he turned around and he said,
I'm also nervous. I don't really know where this thing's going either. So how about we agree that, you know, we'll agree a position now, but we'll be open to revisiting it as this technology evolves. And he said it was an immediate icebreaker and completely changed the landscape of the negotiations. So I think my takeaway from that is empathy is really important. And actually on the previous panel, somebody also mentioned empathy. And I think it's true, like just, you know, the idea that you're not there to try and win a position, but to actually achieve a mutually satisfactory outcome. And yeah, just actually talking on the level with each other, I think can honestly save, you know, a lot of time and angst.
Yeah, and I think that's a really good point, and we had the perfect lead-in, so thank you to the panel before of talking about how important contracting and agreeing things up front can be, but having those discussions and really taking a personal approach to some of these things and putting it out on the table can be really helpful. Ivana, how about you?
I find it's really interesting that you've given an example like that, because I think my example also goes not to necessarily the legal issues, but to the other stuff. So I was thinking, being a technology agreement session, it has to be a technology agreement that I have an example about. And I was thinking about a project 2 years ago that involved the first ever cashless gaming in the gaming industry in Australia. And it's actually something that Maddox helped with. So thank you, Greg and team at Maddox. But it was a complex project, many different parties. We had government, we had technology providers. And from a legal point of view, it was also complex because it involved not only the usual contract issues and privacy and IP, but we also had a regulator to get their approval. We had AML and know your customer issues. And so and the outcome was successful, that we were allowed to go ahead with the trial. But the lesson I took out of that is, again, there's a lot we learn in terms of the law that's involved, but there's so much that's actually just getting the project together, juggling multiple pieces of work, multiple departments, making it all work for the business, but also how you communicate, you know, changing your style, internal stakeholders, external stakeholders, how you influence, how you negotiate. So I think all of these soft skills are in fact so imperative to what we do, on top of all of the legal stuff that we have to be on top of.
Yeah, no, I often say being a contract negotiator, it's a little bit like acting. You know, you get to go and you get to play a role, and you know what's important to your clients, and being able to do that can be fun at times. It's why I like it. Yeah, no, I think it's a really important point as well. And Asha?
I was thinking about my journey to the technology sector, and I started in private practice, not as a technology lawyer, and then moved in-house to a technology company. So contract's a contract, but I think, you know, the fact that it's about technology, it's very important to understand what services or products you're offering. So I don't think many of us would have an IT degree, but I think it's important to speak to those specialists or with expertise to try and get an understanding as to what it is, how it works, the context. And I think you'll find that most tech experts are very happy to sort of explain it in a simple sort of way so that we can understand it and get a better idea of the risks. So, and I've also moved from sort of services to products, hardware, software, so there are differences in those contracts and different risks, so I think understanding that is important.
Yeah, no, absolutely, completely agree with that. So following on some of those stories, Ivana, was just wondering if you had one key piece of advice to a lawyer who's maybe not used to negotiating a technology contract, for instance, what would that be?
I think it would be, sorry, this is too loud. Get to know the technology really well. So every clause in that contract is going to be influenced by what the technology is, from your key clauses like indemnities, warranties, liability caps, to everything else in between. And so if you think from a risk perspective, there's quite different risks depending on what the technology is, and there's such a spectrum of what it could be. So on the one hand, if you have a piece of hardware that someone's made that perhaps gets plugged into electricity and sits on your customer's premises, then, you know, worst case scenario might be, well, if the wiring is faulty because of whoever made the device for you, you might have a fire, the device will burn down, but the client's premises burned down, people injury possible. But like, compare that to a piece of software that is going to churn personal information, where your biggest concern is data breaches. So then you need to kind of really understand the data flows and what's going on there. So the one piece, if I can limit it to one piece, is really get to understand the technology, because it influences everything that you're going to do.
Yeah, no, I think that's a really good piece of advice. And then also, I think on the back of that is understanding that, but also then understanding who's responsible for what off of it, right? And how does that responsibility get divided up? So you can then hopefully attack it and say, okay, well, this is yours, this is mine, and then we can kind of come to a mutual understanding around how to move forward from there. Asha, I was wondering off of that, now obviously understanding the technology is important, but is there anything else that you find in your role for preparing to negotiate a technology contract comes in as well?
I think just sort of properly preparing and making sure even before you get to the negotiation table with the other side, get the right people in the team. So to go through the contract, the commercial issues, the technical issues, if there's any sort of finance clauses, so you have that sort of bedded down and aligned view on that before you even enter the negotiation room. In terms of, and then the right people at the table in the negotiation that you have there, people that can answer the questions. I personally don't want to sort of go into detail about the technology solution, but if that's needed so we can talk about the risks, then you have to have the right person there. My personal preference is before you get to the negotiation table, if you're sitting around the table, to try and limit the number of issues. I think most parties don't want to spend sort of 3 hours going through every single clause, so see what you can do before you enter the room to really try and narrow down those issues. And I would also say go to the big ticket deal breaker items first, because if you can't agree those, if you spend hours and hours negotiating the small fry, at the end of the day, one or the other party might have to walk away because of the deal breaker position. So it's better to know that up front than waste a lot of time on negotiations.
Yeah, and I will say from experience, those often get left till the last because they're too hard. They're going to go in the too hard bucket, and then you spend a lot of times, and if you can't. I did one piece you said there, which I think is really important, is having the right people involved in those discussions and negotiations. And especially when I was in-house, one of my pet peeves was when someone would come and say, oh, well, just let the lawyers deal with it. It's the contract. Just let the lawyers go and negotiate it. It's like, no, that's not how it works here, right? Like, we need to understand, we need that business perspective. It is a commercial agreement at the end of the day. Most of these things, all of the risk positions, things like that, are generally commercial in nature, but we also need the people who understand what's happening, how it's going to work, and how those risks will play out. That's a key part to this, so I think it's a really good point as well. Now, Janine, given your experience, I'm sure you've seen some share of successful or maybe less successful negotiations over the years. What's one key you would say to making the process for negotiating a technology contract, or any contract really in general, a little bit more successful or a little bit easier?
Look, I mean, I'd echo what's just been said. I think those things are critical. Understanding not only the technology, but also what's the business objective in having that technology? What's going to be the upside of having the technology as against not having it? Because I think that does also put a dose of reality on the negotiation, and you can also figure out then, what are the things that are really going to be important in the negotiation, and what are things that you could give away easily. So honestly, I'd say a lot of what's just been said. I also think sometimes it's quite useful to, and you've got to sort of figure out which negotiation this is going to work for, but sometimes getting together with the lawyers and also the business people absolutely have to be in the room, and sort of laying out your stall up front. So, really, because it's important that not only do you understand internally what your business's objectives are, but also what's the other side. And I think if you just kind of say, okay, high level, what are the key concerns for you guys? Then that'll help to focus, the negotiation. You're not going to waste a lot of time talking about other stuff. I will say I have a slightly contrary view on the the things we all don't want to talk about. I think sometimes, yes, it's great to try and discuss and negotiate those up front, but sometimes it's hard to take a position on those issues without seeing the whole big picture and being able to advise, so if you're going to agree very non-standard things that your business doesn't typically do, that may have a knock-on effect on cost, exposure, risk, then maybe you're going to have a different view about, the things we don't like to talk about. Yeah, no, so I think those things are important as well. But also in terms of streamlining things. So sometimes I know some of my team like to do a negotiation table, which can be really, useful, because then you've sort of got what are the clauses that are in contention, what's your position on them, then use that as a tracker with the other party to sort of like, it's all visibly laid out there. It can sometimes get a bit away from the contract itself, and then people get lost and they can't, but it has its advantages. And I think one of the useful things about that is it's like that sort of, when things go green, it's very satisfying, and it also helps you to then say, okay, we've just got these few things left. So the agreed, okay, green, whatever you want to call it, can be quite helpful as well. So, that's maybe just a very practical thing.
And seeing progress can be very motivating for people as well. I might just add to this, one thing that I find can be quite helpful in this, you can look at it both from a supplier and a customer perspective, is keeping a little bit of tension can be helpful for your position. So whether that be, leverage in terms of saying, hey, there are other vendors out there, if you're from a customer's perspective, saying there are other vendors, we can go somewhere else. Not necessarily putting all of your eggs in one basket, because it does put you at a little bit of a disadvantage in terms of if somebody knows you really need to get something done on a tight time frame, they have a little bit more leverage than you might. And I think that can go on the other side as well from a supplier's perspective of really making sure that you're not necessarily showing too much eagerness, or that everything is relying on that, or if you happen to have invested a lot of money that you're really already in the project, and so you're really counting on getting it across the line, just not showing all of your cards necessarily up front can be really helpful. And sometimes that can get a little bit lost in people's excitement of getting things across the line and whatnot. So just thinking about that as well, just to kind of keep things so that you can make sure you're getting the best bargain that you can, whichever perspective you're coming from.
And that's where the private law perspective and the in-house perspective sometimes I think can diverge. Sorry, I'm just jumping in, but going back to my opening line, which I think is about, you need to make it a win-win situation, and getting away from the adversarial, I think is also important. But I agree with you. I mean, in every negotiation, there are going to be things that are important to each party. I actually like to understand where the counterparty is coming from, and I like them to understand where I'm coming from, because I think we'll just get cut through a lot quicker. But you're right, it's a balancing act.
It is. It's a balancing act, and and I think it's just making sure you're thinking through those things. That I've just been in too many situations, let's say with clients, that have let the horse out of the bag, or let the secret out of the bag, that, okay, we're now down to just the one vendor. They know that you're up against the timeline, and, they've, dug in their heels, or vice versa if you're on the supplier side with a customer that says, oh, we really know that they need the cash right now, or they need, to get this investment across the line, and then therefore they're kind of taking advantage as well. So yes, we do want to, and it's one of the things I love about working on contracts is you're working towards a common goal together, as opposed to some of the disputes, but want to make sure that you are putting yourself in that best position to do that while also working together. Just changing topics slightly. Obviously, the world around us is constantly changing. Technology is evolving and changing at a very rapid pace, whether that be the topic du jour, such as AI or otherwise. Ivana, just a quick question, or maybe not so quick, but do you have any tips as to how best to actually understand the technology? We talked a lot about making sure you're understanding of it. How do you make sure you are getting that information, and how do you help your business to kind of understand what risks may be coming out of this new technology?
Good questions, 2 questions there. On the first question, you could do the I'm a dumb lawyer, please explain it to me. I don't know how many of us have used that one before, or perhaps you have, I use it, I'll be brave, or perhaps you have IT and science background, so that helps you. But the two things that come to mind to me that have helped is, one, ask your business for a demo or a prototype. So depending on what the technology is, your business might be tinkering in the background, creating whatever it is that they want to make a better version of. And so you could literally just ask them, show me, which will give you so much more information about what's being done. Even if they don't have a prototype, they don't have the demo ready yet, I would still encourage you and your legal teams to get those demos as technology is released. Create a culture of the business coming to you to tell you about this new product, this new hardware, this new software. And apart from that, helping inform you to be able to do your job better as a lawyer, it's actually fun. Like, how many times have I said to my team, like, we just look at contracts all day long, please take me out, show me a piece of something that's exciting. And so the business is quite active and wants to help. So that would be one tip. And the other one is, if there is personal information involved, I would say PIAs, which are privacy impact assessments, they are an absolute gem of information. You don't have to ask the questions yet. The business gets to fill in and answer a whole heap of questions about exactly what's going on, how it's going on, and if you're lucky, you'll get a beautiful diagram of data flows. So that is another trick that I've found that's not obvious, that will give you a lot of answers without having to ask questions. And back to your second question, so it's not a quick one. You said quick answer, but here I am still going. On the risks side, every new technology does absolutely come with risks. And when I think of risks, I'm looking also at legal, reputational, regulatory, privacy, security, modern slavery. You know, who is making the components and how? And so what I've seen companies do well is if they actually have a system where any new piece of technology has to go through a comprehensive questionnaire that's designed to address all of the risks. And when I say comprehensive, it doesn't mean that they spend 100 days and do 100 questions. You can still have an efficient way for the business to answer questions. If there is a red flag with any answers, then they get sent off to the department to identify and mitigate the risk. So if it's, if there's personal information, off you go to do a privacy threshold assessment or privacy impact assessment. If it's modern slavery, off you go to get more questions about exactly what's being done. And the beauty of this, I think, is for the business, they get to see the questions, they get to see their answers, so they can connect the dots between why there is a risk. But with things like, say, PIAs, with the assessment they get to do with each of the departments, they actually also then are held accountable for how the risk is mitigated. So they know what the risk is, and they know what needs to be done to mitigate it. So this is like an organic way that the business gets informed exactly what the risk is. So they know this not just for now, but for the future, that this is how you get it down. So that's what I found.
Thank you, Ivana, and thanks, Greg. Sorry, you're just going to press pause. 19 minutes to go until lunch and until the end of this panel session. Any questions about contract negotiating? I see one hand from Team Alpha. Any other hands? Team Charlie is very, very desolate over there on the end. Any questions? One hand only so far? Okay, everybody wants lunch, looks like. If you can introduce yourself as well, please. Yeah.
Thanks. I'm Vinod Sharma from the legal team at Cisco. I think I've dealt with a few of you in various capacities, whether it's in the channel or in customers or other aspects. But the question I've got is, if you have a seat at the table with, say, the top 5 to 10 software companies in the world, what would be the top sort of 2 or 3 issues or pet peeves that you have, whether it's their terms, whether it's their processes, whether it's just the experience, in terms of areas where they can better standardize, because you're often having to deal with terms. Sorry, I've got an issue, medical issue at the moment. Not at the moment, but I've had one, which is why I'm stuttering. But yeah, so.
I think if I could wave a magic wand, I would say to all the regulators in the world, could you just get together and agree a standard that we can all comply with? Because, yeah, and by the same token, every software provider, could we all just align? I mean, obviously putting data security, issues to one side because then the hackers get in, but whatever. I just think we spend such a lot of time on trying to navigate the complexity of multiple regimes, of different requirements across different segments. I just think we need, a greater degree of standardization, basically. That would be my, yeah. I don't know if that answers your question, but I had to say it.
Anyone else have? I guess I would just say, and this is probably more speaking from my client's perspective as customers, is dealing with some of the bigger technology companies. It can be frustrating at times. The process can be frustrating. The terms are either quite complex or they are very favorable, obviously, to the provider and are then not very negotiable. So that can present issues when you do work in a regulated environment. For instance, if you're a financial services company, right? There can just be some tension there of trying to figure out how to do that. So I think conveying from their perspective just a little bit more flexibility and understanding around the different regulatory environments that we are working in. And I think from my perspective, as someone who practiced law in the US for quite a while and then moved to Australia, there is a little bit sometimes when the terms are global, that they don't necessarily aren't fit for purpose always for Australia, and that can be frustrating for clients here as well. So I would say just making sure that if you are a company in that environment and you're working with clients in Australia to kind of, yes, this kind of dovetails off of this, so can't we just have one set of terms? But unfortunately we don't right now, and so making sure that your contracts and whatnot are set up to work in the place that they are actually going to be operational. Because the amount of times we see that of saying, oh, actually this doesn't work in Australia for various reasons, and then have to educate or feel like we're educating the other side around that.
But I do think, particularly in the SaaS world, data security is obviously the principal concern for buyers. Having transparency from your vendor around what their security profile is, their protocol, their processes, their framework, their certifications, I think that cuts through a lot as well, and I think that's really important. Like I always say to the business, that's the most important thing you can do for a customer, is provide them with the tools to share with their risk management people, what comfort they're going to get from using this as opposed to sticking with, something that, paper or some old legacy system. So I think that's also key.
Thanks, Janine. Thanks, Greg. Sorry, before I hand back to you, Greg, and you can take us into lunch for 14 minutes left, and thank you, Vinod, for that question. I just wanted to say, if you take a great photograph of today's conference or tomorrow's conference, you post it on LinkedIn, tag Law Ninjas, you might get a prize. So I've got some amazing chocolate hampers from Day One Recruitment here, and 2 of you in this room have already done it without even any incentive, and I wanted to say thank you. So we've got Lauren, and coincidentally the other person is Sonia, who's sitting right next door. They've posted some pretty cool stuff on LinkedIn today, so thank you so much. If I can give you these hampers. We've also got other prizes. We've got Nando's vouchers, fitness vouchers, all that kind of stuff today and tomorrow. So do post on LinkedIn, tag Law Ninjas, and you might just win. Greg, over to you.
Thank you. So that last comment was actually great. It was a great segue into our next topic, which is talking about data security and cybersecurity. It's obviously a key issue for a lot of businesses, both from a personal information perspective, but also just confidential information and making sure that clients' data is secure. Ivana, before you were talking about PIAs and whatnot, and if I can do a little plug here, we actually have a new tool out. It's called Maddox Aware. Sonia, who just won a hamper, is sitting over there. She's a fellow partner in our TMT team. She's worked really hard to work on creating this tool that helps clients to understand their data flows and their data maps, understanding where your information is being shared in terms of with third parties, what those third party contracts look like, but really getting a baseline so that you can then go and do the PIAs and those assessments and whatnot. It's a really amazing tool, and I think is really important to understand that as then you can go into the contract with the information of, okay, what are we getting access to, what is happening? So with that background, Ivana, do you consider that contracts are important in helping to protect and secure your business's confidential information, data and personal information? And in your experience, have you seen an impact on how businesses are approaching contracts as a result of the security incidents that we've all seen in the media recently?
Yeah, look, really good question, and great way to also indicate that there's more to privacy than contracts. So I love that you've given the background to PIAs and data flows. So yes, data breaches are absolutely still on everyone's mind and a top priority, and contracts are important in terms of protecting us. And I think it only takes a company going through a data breach to actually have privacy awareness just skyrocket. But I don't think the answer is solely contracts. So that's why I think it was actually good to give that preamble. And that's because your robust privacy framework kind of sits in the background, and your privacy maturity and the way you're lifting that sits outside of contracts, really. So there's a lot of work that has to happen outside for your company. Things like, are you training your staff so that they know not to click on phishing emails? Are you doing proper due diligences of your suppliers? Critical, not a contract yet. Are you destroying your data in line with your data retention policies? Like, I could keep going. There's a lot of stuff that happens outside, but bringing it back to contracts, yes, there is a way. What I've seen companies do really well is use the due diligence that they're doing in the background to feed what should go into the contract. So there are kind of privacy clauses that just kind of get added because that's what's done. But then there are those companies that are doing the PIA and things that come out in the wash. The supplier's not done this. They don't have a data breach policy. It informs you, A, whether, this is what the risk is. Do you even want to go ahead? But B, can you put a clause in the contract to address that and get the supplier to do and cover that risk? So that's something that's being done well. But then I think also I've seen people just use privacy clauses almost like alternative dispute resolution. They just add them because, it'll never happen. I just need to have them. And I think it takes a company going through a data breach to go, actually, it really matters when I get the supplier to notify me of a data breach. Like if anyone's got GDPR issues, 72 hours. Like, so you really care what's in there. You really care if you've got joint obligations, like if the data is owned by someone else and your company was processing it. You really actually care how you notify the regulator and the public. So I think a lot more care is being taken in this space as well. But I think it's a joint effort, contracts and outside of contracts.
Yeah, no, I completely agree. And making sure that the business does understand how that is all working, what those data flows are looking like can be really important, and especially when you're working with new technology or you're launching a new product or something along those lines. I've found working with the business especially and trying to figure out, okay, where is the data coming from? What are we doing with the data? Where does it go? Especially, I do a lot of advertising technology work, and just understanding all of that can be really important, and making sure you're kind of mapping that all out, and those tools can be really impactful for helping with that. Switching gears slightly is another hot button topic in any technology contract, which is one of those ones we talked about at the beginning of, do you cover in the beginning or the end, but is liability. And as it is in any contract, whether technology or not, we, I'm sure all have spent probably too much time, we might say, advising our clients on liability and negotiating liability type provisions. Janine, are you seeing any trends in the marketplace regarding how liability is being addressed in contracts, or do you have any tips around how to deal with that?
So I might not quite answer the question the way that you wanted initially. Sorry to be contrary. Look, I think what I find interesting is, when I first started negotiating technology contracts, we were principally talking about installed software. And, you know, the sort of understanding was very different from SaaS. So I think what, you know, echoing what's been said before, contract's a good place to focus the mind on what the issues are, but I think it's a pretty blunt instrument for actually helping you out. So, you know, you don't want to be in a situation where the thing you're looking to is the liability clause. Like, by then the damage is done, right? Dealing with providers who have a good information security framework in place is absolutely critical. And I think if there's comfort around that, then the liability clause becomes slightly less important than if you're dealing with someone where you've got no confidence in. And I've seen that understanding really grow. I think people have quite a sophisticated understanding of what SaaS delivers, and what things are really important to understand. So, you know, I think the idea that you get uncapped liability for data breach, I'm not seeing that sort of as an ask anymore at all. I think people understand that you're getting something else with SaaS. I think also important to bear in mind is if things go wrong on a SaaS platform, they're not just going wrong for you, they're going wrong for that provider's entire customer base. And that is a great stick to keep people in check, right? Because nobody wants that situation. So I think part of it is really to ensure that you are dealing, if you're on the customer side, that you're dealing with vendors who have those certifications in place. To me, that is far more important than that, you know, the liability position. And yeah, I mean, look, every software provider's got a standard position. They seem to be broadly consistent in my experience. I haven't seen much divergence on where you go beyond the standard. I think it's still, you know, pretty much the same as it was. I mean, yes, we've had these sort of little interesting issues arise in Australia of late, which have grabbed the attention. I think the one interesting thing to note is often it's with legacy software, installed software, which is a bit of a Trojan horse. So, you know, in a way, outsourcing that huge investment in secure technology is actually a good way to deal with it. And also, whose data center is in play? Because if you've got those really quality data centers, that's also an essential part of it. So I didn't entirely answer your question, but I do feel quite passionately about that, right? That if you're getting to the liability stage, you're gone anyway. I mean, you just don't want to be there, yeah. Yeah, no, and I think it was one of the points that the last panel really focused on as well, is you really want to try and head off. Someone, I think may have been you, who said, said you don't even want to look at that, what it says. You want to try to cut it off before you get there. So that's obviously very helpful. But I will say, I do agree. I think there's a little bit more of a movement in terms of thinking about liability in a more bespoke manner and really thinking about the risks and the product and whatnot, rather than just having a standard template that you just kind of throw out. And again, this is on the customer or the supplier side of, really thinking about, okay, this is what we've done, and I'm actually probably speaking more from the customer side. If you have a customer template and, these are just the positions that you've been using for a really long time, is thinking, okay, do we need to rethink some of those positions? What's it based off of? What is the actual risk here? And working with the business to try and quantify what that risk is, so that you're coming armed with the information of saying, this is why, this is the justification for what we're asking for, which I think probably goes a long way on both sides. Yeah, exactly right. Asha, I think I might turn to you next, which is another thing that gets a lot of airtime during negotiations is indemnities, and that's whether that be for IP infringement, breaches of confidentiality, privacy, or otherwise. Just curious whether you thought sometimes an indemnity on its face may provide a party with a false sense of comfort, or if there's anything that you think a party should be mindful of when negotiating indemnities in a contract.
I think you should always be mindful of indemnities because of their ramifications. I mean, it's not often that they're utilised, but when they are, it can have big impacts on the party that's indemnifying. I would say it's definitely, I mean, I've got a room full of commercial lawyers here who, in all contracts, it's always an issue. So I'm not going to talk too much about it, but yeah, I think sometimes you really need to ask, is it necessary and reasonable? And then put some parameters around it, you know, is there a duty to mitigate? Is it subject to a cap? You know, do you exclude indirect losses, those type of things? I guess with technology contracts in particular, I think, you know, IP claims by third parties for IP infringement is probably more of a big one. And if you do have that in your contract, you know, who's going to, if there are proceedings, who's going to manage those proceedings? Because I think the vendor often wants to be in control and make the decisions on that, which I would have thought seemed sensible.
Yeah, no, I agree with that. And again, I think it's a little bit more of a really thinking through those indemnities, making sure they make sense, thinking about what, you know, guardrails you can put around it, again, from both the supplier and the customer's perspective of what are you really focused on, what are the risks, what needs to be protected on both sides, and really thinking through those things rather than just kind of throwing things in because you can, or you know, that's just going to create a little bit more friction, right? So if you can be a little bit more intentional around what's going in there and why, and have that justifiable position, it can go a long way to easing some of that negotiation friction around those points. Just have a minute left, so might just...
Yeah, any final questions before lunch? Come on, you've got questions. Okay, we've got one hand there. All right.
Thank you for that. I just had a really quick question on any tips on what not to do in negotiating a technology contract.
I don't think that's a quick question.
I was going to say that's not a quick.
We could probably do a whole nother session on what not to do. But maybe I'll pass, see if anyone's got just a quick one.
I could say, I don't know that it's specific to tech contracts. Oh, sorry. I don't know that it's specific to tech contracts. I would say, don't just look at the words on the page and say, oh, I don't like that clause, you know, let's go to town on that one, because if you're just sort of playing with words, you're going to get nowhere. It's just going to take such a long time to get to an outcome. So, yeah.
Pick your battle, is that what you mean?
Yeah, I think, and again, what we've said again and again, I think, during this conversation, which is make it real, like bring it back to like, what are you actually talking about? Understand the business. And this is probably something I'd rather do than not do, is bring your InfoSec people in right at the beginning, get them involved in the conversation, get them talking to each other, because often when they talk to each other, it just so much goes away. You know, you need your SMEs to be, so keeping them out the room. And actually I find the same with lawyers, like people who, like if procurement says, no, we're not bringing our lawyers into the conversation, that just, it often just is so counterproductive, you know. Yep. Lawyer to lawyer is good as well.
All right, I think we've used our time, so thanks for everybody, and thank you to our panelists.
Please give us a big Asha, Ivana, Janine, Greg, thank you. Get a nice group photo on stage. All right, so for those of you who were here last year, we all went for lunch through that little door there, so we're not going to do that because that was a traffic jam. We're going to open this door here. So the way you get lunch is you line up here, and we've got a table so you can stand on either side of the table, and we've got plates. Enjoy. So we'll be back in about 45 minutes. Thank you.